All right, guys, welcome to your flex day, first flex day, Tuesday, September the 12th. These are the notes that you're going to need for today. And as I mentioned, there is a big rumor going around that there's going to be a pop quiz tomorrow over these notes. Okay, I cannot confirm that, but I have a pretty good source that tells me that there might be. So make sure you take some good notes. This particular chapter, Chapter 3, deals with the dual court system, so we'll look at the federal and the state courts. The first thing, though, that we need to talk about is how to resolve a dispute. You know, when there's an issue between two parties, how do we resolve that? The first one is through litigation, which is basically means that you go to court. You allow the court to settle the dispute for you, and that's called litigate. And then the process is called litigation. Okay, that's the obvious one. That's the one we'll get to into more detail here later on. But there are two other forms of dispute resolution that are known as alternative dispute resolutions. These two ways, mediation and arbitration through a mediator or arbitrator, are ways that you can resolve a dispute without going to court. Okay. The two are very similar, but there are some differences, okay? The first one, if we look at mediation or a mediator, well, actually, let's talk about both of them at the same time. Both of them involve a third party to help with the resolution of the dispute, okay? So if two parties have an issue with each other that needs to be resolved, a lawsuit of some kind or whatever, injury has occurred, then they would hire a mediator or an arbitrator to handle those disputes. It's a lot cheaper than going to court, and it's a lot quicker as well. Now, a couple differences when we look at mediation. A mediator will have both parties in the room together and then try to work out the differences and then come up with a suggested resolution. Okay? Arbitrator, in an arbitration situation, the two parties are in different rooms. The arbitrator will go back and forth to each party saying, hey, well, they want this. Okay, I'll go talk to the other party. Well, they want this. And then the arbitrator's decision is binding. In other words, whatever the arbitrator decides, the court will uphold that. That is like you are going to court and a judge is ruling on that decision. In mediation, it's just a suggestion, and you do not have to agree to the mediator's opinion or proposal to resolve it. Okay. Let's look at the litigation, and we'll look at the court system. When you hear the term trial courts, this is where a dispute will go before a court. This is where they first are heard, are through trial courts. These trial courts have what's called original jurisdiction meaning that they hear the case for the first time and then they render a verdict. Verdict, remember, is the court's decision. In civil law, and we'll get into this more later throughout the class, but in civil law, a court will either find for or against the plaintiff. The plaintiff is the party that will bring about the dispute to the court. And again, you don't need to know that right now because we'll get into that whole thing later. But the verdict, again, is basically just the court's decision. Then you have what are called appellate courts. They review the decisions of those trial courts and see if any errors were made. Okay. What will happen is there'll be a few different things. They could either affirm the decision, which means that they uphold the lower court's or the original trial court's decision. They could reverse it being the decision that the lower court made, which means they overturn it, or they can amend it, which means they change part of the outcome, or they can remand it, which means they send it back for a new trial. Maybe there was an error that they found in the process, and that error they feel warrants a new trial rather than them ruling on it themselves. Okay, a couple things, or a big thing to know about appellate courts is that they cannot change the factual determinations of a jury. They being the appellate court, is only looking at the details and the process to find out if an error of any kind had occurred. Okay. Now let's look at the federal court system itself. There's federal and state court. We'll look at the federal court system today, and then when you guys come back Wednesday, we'll talk about the federal or the state court system. Federal court systems have 3 levels of general jurisdiction. Again, just to remind you, jurisdiction means the court's authority to rule over a particular case. Each court has a certain type of jurisdiction. And at the federal level, there are 3 different levels that have what's called general jurisdiction. First are called federal district courts. This is the lowest level of the federal court system. Basically, it's the trial court of the federal system. So they hear cases that are brought at the federal level. These guys hear them for the first time, the federal district courts. Okay. So any federal questions, and then they also deal with what's called diversity of citizenship issues. And this means diversity of citizenship means when that you have parties that are from 2 different states. So somebody in Indiana is suing somebody in California. In order to be fair to both parties, the federal district court gets involved rather than the Indiana state court or the California state court. In those situations, that's called diversity of citizenship. Second level are the federal courts of appeal. They have what's called appellate jurisdiction. They have the authority to rule over cases that have already been heard at the federal level, and then either do one of those 5 things I talked about earlier with what appellate courts do. Most federal administrative agencies, if there's an issue with them, like the FCC or the DNR or somebody like that, will go to the federal courts of appeal. In the United States, there are 12 circuit courts that are on this on the federal court of appeals, and then there's one that's called the federal circuit. So the United States is broken up into 12 districts, and then with the federal district being right here in Washington, D.C. Okay, so as you can see, big time test question. We are in the 7th district in the state of Indiana. Okay, so again, there are 12 districts with 1 at the federal level, or what's called the federal circuit. Okay, and these guys have jurisdiction over certain cases we'll talk about later. So for the sake of argument, there are a total of 13 districts within the federal courts of appeal, or circuits, I should say. 13 circuits. Indiana, again, is in the 7th circuit. Total, there are 179 judges at the federal level, and they have a lifetime appointment. Average salary is $213,300. Excuse me. So yeah, $213,300. That's the average salary for the 179 judges in the 13 circuits. Lifetime appointment as well. This is the 7th U.S. Circuit. This is in Chicago. This is the one that we are a part of here in Indiana. It's called the Everett McKinley Dirksen Courthouse in Chicago, Illinois. So that might be a test question. Where is the 7th Circuit Courthouse located? Chicago, Illinois. It's called the Everett McKinley Dirksen Courthouse. All right, that's where we're going to stop for today. We will pick up where we left off on Wednesday. If you want to go to Canvas now, the next assignment in the mod is your final part of e-learning. Hope you're having a great day.